Hello everyone, we are back. As you all know that we were already discussing the case laws of contract. Now this video is in the furtherance of that particular video. This is the second video in that series. So the first question is, following is a case on promissory estoppel. Correct answer is Kedarnath versus Gauri Muhammad, Delhi Cloth and General Mills Private Limited versus Union of India, both A and B. A valuable consideration Valuable consideration in the sense of law may consist either in some right or interest or benefit accruing to one party or some forbearance, determinant, loss, responsibility given, suffered or undertaken by the other is well explained in. Correct answer is Curie versus Miza. Promissory estoppel against the government agencies is decided in. Correct answer is Delhi Cloth and General Mills Limited versus Union of India AIR 1987. Consideration means a reasonable equivalent or other valuable benefit passed on to the transferor to the transferee. Similarly, when the word consideration was qualified by the word adequate, it makes the consideration stronger so as to make it sufficient and valuable having regard to the facts, circumstances, and necessities of the case. Our principle was laid down in A. Sonia Bhatia versus State of UP. Read assertion and reason and answer the using code given below. Assertion: a contract is a property in the nature of a promise supported by some consideration upon which either the remedy of a specific performance or that of damages is available. Reason is our principle is laid down in Sunrise Associate versus Government of NCT Delhi. Correct answer is B. Both A and B are incorrect. The doctrine of promissory estoppel was used by Justice Denning to uphold the promise of a creditor to accept a smaller sum in discharge of a larger sum, if such a promise is acted upon by the promise, notwithstanding the absence of consideration. Identify the relevant case in which the doctrine was so developed by Justice Denning. Correct answer is C. Central Inland Transport Corporation versus Mumbai Port. The principle of privity of contract was held as not applicable in an action for tort in Ashby versus White. Match list 1 and list 2. List 1. In list 1, the options are Durga Prasad versus Baldev, B. Abdul Aziz versus Masoom Ali, C. Dutton versus Pule, uh, D. Tweddle versus Ettingson. And list 2, we have to match the following. Here the correct answer is Durga Prasad versus Baldev. Correct answer is act was not done at the desire of the promisor and hence no consideration. Abdul Aziz versus Masoom Ali, correct answer is the party has done nothing in response to unilateral promise and hence no consideration. In C, Dutton versus Poole, the correct answer is the agreement may be enforced by the third person for whose benefit agreement was made. D. Tweedle versus Ettingson. The correct answer is no stranger to the consideration can take advantage of contract although made for his benefit. Which of the following is the subject matter is dealt under the case law Chinaya versus Ramaya? C. Consideration. In the case of McGregor versus McGregor 1888, the wife withdrew her complaints as the husband entered into an agreement with her on the condition that if she withdrew her complaints and refrained from pledging his credit, he will pay for her an allowance. Correct answer is parties had the intention to have a binding contract between them. The case Balfour versus Balfour deals with intention to create legal relationship. Intention not to create a legal relationship was clear from the conduct of parties. Which among the popular cases deals on the topic? Correct answer is Balfour versus Balfour. The case of Mohri Bibi versus Dharmodas Ghosh. Options is the decision of Supreme Court of India regarding extraordinary contracts has laid down that in India minus contract is void ab initio. Mohri Bibi versus Dharmodas Ghosh, void ab initio, has laid down that India's minor contract is void ab initio. Mohri Bibi versus Dharmodas Ghosh is an important case. Again, it has been asked minus contract. The case of Mohri Bibi versus Dharmodas Ghosh is based on the provision of Indian Contract Act Section 11, which decision has laid down to the principle that contract by minor is void ab initio. Mohri Bibi versus Dharmodas Ghosh. Read assertion and reason, and with the help of quotes given below, point out the correct explanation. Assertion. In Mohri Bibi versus Dharmadas Ghosh, Sir Lord North observed the question whether a contract is void or is voidable does not presuppose the existence of a contract within the meaning of Contract Act and can arise in case of an infant reason. Ever since this decision in Mohri Bibi versus Dharmadas Ghosh, it has been doubted that a minor's agreement is void. Both A and R wrong. Consider the following statement and give the correct answer with the help of code given below. The case of Mohri Bibi versus Dharmadas Ghosh. Options are: has laid down that minor's contract becomes valid when he attains majority. Is the decision of the Supreme Court of India regarding minor's contract. Is the decision of the Privy Council regarding voidness of minor's agreement. Has laid down that the contract without consideration is void. Correct answer is C. Is the decision of Privy Council regarding voidness of minus agreement. In Mohri Bibi versus Dharmadas Ghosh was finally decided by Privy Council. Which of the following was never held or observed by the Privy Council in Mohri Bibi versus Dharmadas Ghosh? Option A. An agreement made by a minor is a void. This was observed. The minor's agreement being void, he could not be asked to repay. This was observed. Section 64 and 65 of the Indian Contract Act 1872 allow compensation to be made by a person who gets undue benefit in a case, but those sections do not cover the case where the agreement void ab initio in the case of minor. This also was observed. So the question here is which was never held. Therefore D is the right answer. Since the loan had been given to the minor with the full knowledge about his infancy, the money lender can still be asked to be compensated under specifically Act 1963. This is the right, but this was not observed in Mohri Bibi versus Dharmadas Ghosh. Match list 1 and list 2. Kundi versus Lindstate, B. Tin versus Halfman, C. Roberts versus Gray, and D. Hadley versus Baxendale. Correct answer for A. Kundi versus Lindsay is mistaken identity. Tin versus Hoffman, the correct answer is crossovers. Roberts versus Gray, correct answer is minors agreement. And D. Hadley versus Baxendale, correct answer is measure of damages. Which of the following cases related to the issue of minority in the contract law? Correct answer is all of the above, and these cases are Khan Gul versus Lakha Singh, Ayodhya Prasad versus Chandan Lal, Mohri Bibi versus Dharmadas Ghosh. In Jyotendra Bhattacharjee versus Mrs. Sona Bolon Bora, it was held that the onus of proving unsoundness of mind of a person always rests upon the person who alleges such a state of mind of another person. This was held in Jyotendra Bhattacharjee versus Mrs. Sona Balon Bora. Fraud was defined in a well-known English case, Derry versus Peake. Match list 1 and list 2. List 1 says mistake as to subject matter of contract. A. Mistake as to non-existent subject matter. B. Mistake as to title or right. C. Different subject matter in mind. And D. Mistake as to substance, nature, quality of matter. The correct answer is for A. Mistake as to non-existent subject matter. Gustavus Courtier versus Robert Hastek for A. Mistake as to title of rights, correct answer is Bell versus Lever Brothers Limited. Different subject matter in mind, correct answer is Raffles versus Wichelhaus. And D. Mistake as to substance, nature or quality of subject, the correct answer is Sheikh Brothers Limited versus Optioner. Again, the question is relating to match the following. Here, list 1 is types of vitiating elements of a contract and list 2 is relevant case law. Types of vitiating elements of a contract: A. Undue influence, B. Misrepresentation, C. Fraud, and D. Mistake. So the correct answers are for undue influence, correct answer is Lancashire Loans versus Black. For misrepresentation, correct answer is Nursery SPG versus Vug and Company Limited, Ray. Fraud, correct answer is Derry versus Peake. And for mistake, correct answer is Jagannath versus Secretary of State for India. Lancashire Loans versus Black. Misrepresentation, Nursery SPG versus Vug Company Limited, Ray. Fraud, correct answer is Derry versus Peake. And for mistake, correct answer is Jagannath versus Secretary of State for. According to Lord Herschel, in the case of Derry versus Peake, fraud is proved when it is known that false representation has been made. Options are A. Knowingly, B. Without belief in its truth, C. Recklessly, whether it is true or false, and D, any of the above. Correct answer is D, any of the above. Knowingly, without belief in its truth, and recklessly, whether it is true or false. Again, the question is match the following: concept and decision. List 1 is concept and list 2 is decision. Here, option in the list of concept, option A is undue influence, B fraud, C mistake as to identity of parties. For undue influence, correct answer is Ladli Prasad versus Karnal Distillery Company. For fraud, correct answer is Terry versus Peak. This we have already discussed. And mistake as to identity of parties, correct answer is Ingram versus Little. In Khemchand versus Behram 1888, in context of public policy relating to a contract, it was decided that help given or promised to a dancing girl is not tainted with immorality. Which one of the following cases can enshrine the present position of the doctrine of public policy in India? Correct answer is Gherulal Parekh versus Mahadev Das. Match the following: list 1 and list 2. List 1 consists of heads of public policy: A. Trading with enemy, B. Trafficking in public offices, D. Interference with administration of justice, and D. Marriage brokerage contracts. We have to match them with the relevant case law. Correct match with the heads of public policy with case laws are trading with enemy. Correct answer is Nand Kishore versus Kunj Bihari Lal. Trafficking with public offices, correct answer is Girdhari Singh versus Neeladhar Singh. Interference with the administration of justice, correct answer is Aposte versus Bowden. Marriage brokerage contracts, correct answer is Shiv Sharan Lal versus Keshav Prasad. In which of the following cases the Supreme Court struck down a clause in the service agreement whereby service of a permanent employee could be terminated by giving 3 months notice as unreasonable and opposed to public policy? Correct answer is Central Inland Water Transport Corporation Limited versus Burju Nath. In Carlyle versus Carbolic Smokeball Company, the definition of waging agreement was given by B. Justice Hawkins. The nature of waging agreement was explained in Carlyle versus Carbolic Smokeball Company. The facts of Griffith versus Brymere would attract Section 20 and facts of Krell versus Henry attract Section 56 of the Indian Contract Act. Which of the following case is related to the doctrine of frustration? Correct answer is Krell versus Henry. Which of the following case is related to the doctrine of frustration? Correct answer is Satyavrat Ghosh versus Magni Ram. The first case on the doctrine of frustration as decided by the Supreme Court of India is Satyavrat Ghosh versus Magni Ram. It is the first case decided on the doctrine of frustration by Supreme Court of India. Satyavrat Ghosh versus Magni Ram Bangur, 1954 Supreme Court, is a case on doctrine of frustration. Which of these precedent is related to doctrine of frustration? Correct answer is Satyavrat Ghosh versus Magni Ram Bangur. Which of the following pairs is correctly matched? Mohri Bibi versus Dharmodas Ghosh. This is the correct match. It is related to minus agreement. Hadley versus Baxendale, free consent. This is also incorrect. Satyavrat Ghosh versus Magni Ram, frustration of contract. This is the right pair matched. Lalman Shukla versus Gauridas, capacity contract. This is also wrong match. Doctrine of frustration was laid down by the first time in Taylor versus Caldwell. For Supreme Court, the correct answer, if first time by Supreme Court, the correct answer will then be Satyavrat Ghosh versus Magni Ram. But it is asking was laid by the first time. Then the correct answer will be Taylor versus Caldwell. Read assertion and reason and answer using code given below. It is well settled that if and then there is frustration, the dissolution of the contract does not occur automatically. It depends on the ground of repudiation or breach, or on the choice or election of either party. It does not depend on the effect of what has actually happened on the possibility of performing the contract. Because Lord Wright laid down this principle in Denny versus Mott and Dickinson Limited versus James V. Fraser and Company Limited. Correct answer is both A and R are wrong. Assertion and reason both are wrong. In which case the following doctrine of frustration was recognized in India? Correct answer is Satyavrat Ghosh versus Magni Ram, Bangur and Company. Here we will conclude this video. The remaining portion will be in the next video. Thank you so much. Please subscribe us.